New Mexico Real Estate Basics, page 18. Listed a lot at a price that would yield a $1,000 commission. It sold for full price, and a $1,000 earnest money check was written and deposited into the qualifying broker's trust account. At closing, the owner of the property gave the qualifying broker written permission to keep the $1,000 earnest money located in the trust account in lieu of the commission owed. The $1,000 earnest money held in the trust account, due and payable now as commission earned, must be promptly withdrawn and transferred to the broker's business account, or the qualifying broker could be found guilty of unlawful commingling. What procedures must the qualifying broker follow when the buyer and seller disagree as to how the earnest money should be distributed? Under certain conditions, the qualifying broker is authorized to release disputed earnest money without written consent of the parties. One example is when the qualifying broker is in receipt of a final judgment of the court directing the disposition of the deposit, or there is a final decision of a binding alternative dispute resolution. Another example is when a civil action is filed to determine the disposition of the earnest money, at which time the qualifying broker may seek court authorization to pay the deposit into the court and interpleaded action. How soon do buyers get their earnest money back when they withdraw an offer before it is accepted? Obviously, a written release is not required when a seller rejects an offer or buyers withdraw an offer before notification of acceptance. In both events, the earnest money is returned to the buyer without delay. In New Mexico, it is customary for brokers to keep earnest money checks in their transaction files until offer acceptance. If the offer does not result in a contract, the earnest money check is simply returned to the buyer or tenant. Can the qualifying broker take commission directly from the earnest money in the trust account if the buyer and seller agree just before closing to rescind the contract? No. The qualifying broker may not take the fees directly from the trust account. Should a transaction fail to consummate, the broker under no circumstances is entitled to withhold any portion of the earnest money, even though a commission is earned. For example, sellers accepted an offer for the sale of their home accompanied by a $2,000 earnest money check. After acceptance, the buyers asked the sellers to let them out of the contract due to an unexpected job transfer. The owners agreed and told the buyers they could have the earnest money back too. In this case, when the sellers accepted the buyer's offer, a commission was earned. However, the listing broker cannot hold the buyer's earnest money hostage. The qualifying broker must return the earnest money as directed and look to the seller for compensation for services rendered.